The respondent, a retired government servant, was granted leave encashment of 300 days upon superannuation under Rule 36 of the Sikkim Government Services Leave Rules, 1982. Post-retirement, he was re-employed for over 14 years and sought leave encashment again for unutilized leave accrued during re-employment. The state initially sanctioned the same, but later cancelled it via clarificatory order dated 27 February 2020, stating that Rule 36 limits leave encashment to a maximum of 300 days, inclusive of any extension of service or re-employment. The High Court allowed the respondent's writ petition, holding that Rules 32 and 36 read conjointly, entitled re-employed servants to leave encashment as if they were new entrants. The Supreme Court set aside the High Court's orders, holding Rule 36 applies only to government servants retiring from regular service under the Sikkim Government Service Rules, 1974, and limits leave encashment to a maximum of 300 days on the date of retirement, including extension of service under Rule 31. Rule 32, which treats re-employed servants as new entrants for leave accrual, does not extend the benefit of leave encashment under Rule 36 to re-employed servants. The two rules operate in distinct spheres and cannot be read conjointly to grant a second leave encashment. Re-employment under Rule 102 of the Service Rules is discretionary and not a continuation of regular service. Leave accrued during re-employment does not entitle the employee to additional leave encashment beyond the 300-day limit already availed upon retirement. The state's clarificatory order dated 27 February 2020, limiting leave encashment to 300 days inclusive of re-employment periods, is in consonance with the spirit of Rules 31, 32, and 36. Cancellation of the second leave encashment sanction was lawful. The cancellation of the second leave encashment without a hearing did not violate natural justice, as the respondent could not establish a legal right to the benefit and no prejudice was caused. Leave encashment is a welfare measure grounded in equity and economic security, compensating employees for unutilized leave during regular service. Allowing multiple encashments risks unjust enrichment and financial burden on the public exchequer. The Supreme Court held that a government servant who has availed leave encashment of 300 days upon superannuation under Rule 36 is not entitled to additional leave encashment for leave accrued during re-employment. The High Court's interpretation of Rules 32 and 36 was erroneous. Appeals allowed, impugned orders set aside, no order as to costs.